So, in the previous couple of lessons, we've been talking about the principles of the UK Constitution. We've explored the idea of the rule of law, we've talked about the concept of the separation of powers, and we've been spending a lot of time talking about the concept of parliamentary sovereignty. Now, the principle of parliamentary sovereignty is arguably one of, if not the most important, of the basic principles of the UK Constitution. Now, constitutional scholars will maybe disagree with me in that regard. Some may say that the rule of law is more important. Others may say that the idea of the constitutional monarchy is more important. But I would wager that arguably the most important principle of the UK Constitution is this idea of implied repeal. Of this idea of parliamentary sovereignty. And we've been talking a little bit for the last 2 or 3 lessons about the doctrine of of parliamentary sovereignty. I'm sorry, and this lesson is going to talk about one of the contingent elements of parliamentary sovereignty, which is this idea called implied repeal, as I've been constantly trying to stop saying at the start of this lesson. So we're going to explore some of the underlying principles relating to the principle of parliamentary sovereignty. Almost described as almost subsidiary elements of the principle of parliamentary sovereignty. We'll spend most of our time examining the doctrine of implied repeal of legislation. What does the doctrine of implied repeal actually tell us about the nature of sovereignty of Parliament? Well, it is one of the most important elements of the doctrine of sovereignty that Parliament today will not be able to bind successive parliaments in the future. This suggests that the concept of parliamentary sovereignty is one which is temporal in nature, the idea being that future parliaments cannot be limited and restricted by parliaments of the past. And this suggests that, therefore, because of this, there would be a limitation on parliamentary sovereignty of future parliaments if this would be allowed. And one of the ideas that is representative of this is this idea of implied repeal. The idea that Parliament cannot bind successive parliaments in the future means that Parliament cannot pass a single piece of legislation which would subject future parliaments against their will to it. It suggests that any future Parliament can repeal and replace any of the parliamentary legislation that is passed in this Parliament or parliaments before. And this is one of the interesting elements of parliamentary sovereignty. It doesn't suggest, therefore, that you can't pass legislation which may have some kind of political binding authority. Some argue that things like the Human Rights Act is relatively strong and stable in its ability to bind politically future parliaments because of the fact that it is so foundational and constitutional in nature that it suggests, therefore, that it would be very politically disadvantageous to try and abolish the Human Rights Act. But the idea here is we're not talking necessarily about the political elements of parliamentary sovereignty, we're talking about the legal. And in the context of the legal elements, there is no mechanism which is limiting the ability for Parliament to repeal and replace the Human Rights Act. Now, Parliament has the ability to expressly repeal whichever piece of legislation it so chooses. If Parliament passes a piece of legislation in the future that suggests the repeal of previous legislation, that is perfectly within the remit of Parliament to do so, and perfectly within the remit of parliamentary sovereignty to do so. For example, if Parliament was to pass legislation that expressly repealed the House of Lords Act or repealed the Companies Act, for example, it could do so, and those pieces of legislation would be no longer binding. But what about this idea of impliedly repealing something, using implied repeal? Well, the idea of implied repeal is that where you essentially take a future piece of legislation and you have that legislation contradict previous legislation. The doctrine of implied repeal tells us that owing to the idea that Parliament doesn't bind successive parliaments, the future legislation has impliedly taken away and impliedly repealed the earlier piece of legislation. That is what implied repeal tells us. So where there are two pieces of legislation which seem to contradict each other in some way, the traditional view is that the more recent legislation will have been impliedly repealed and the legislation that existed previously will no longer be in effect, and it would have been replaced by the new future and more up-to-date piece of legislation. So as such, the previous legislation cannot protect itself from being repealed in the future. If you had a contradiction between two pieces of legislation, it is always the most up-to-date and most recent legislation that is going to take precedent. The reason for this is, of course, the fact that Parliament cannot bind future parliaments. And if you had two pieces of legislation, one that was being passed today and one which had been passed 20 years ago, and you had a situation where the earlier legislation was the one that took precedent, then that would imply that the previous parliament that existed 20 years ago could bind the wills and the wishes of the future parliament that is passing legislation today, which is, of course, not allowed. And one example of how this has been illustrated in the case law is in the case of Vauxhall Estates Limited versus the Liverpool Corporation from 1932. The compulsory purchase of housing took effect as a result of a piece of parliamentary statute. Where there was the compulsory purchase of housing, there was the ability for the previous owners of that purchased housing to gain some form of compensation as a kind of remedy for the compulsory purchase of said house. Now, there were two pieces of legislation, both of which outlined the regulation of this compensation scheme. The first of which was the Acquisition of Land Act from 1919, and this used an open marker method of compensation. You don't need to know necessarily what this actually entails, but you should just know that these are two different pieces of legislation which regulates the concept of compensatory remedies for the compulsory purchase of housing in different ways. The second piece of legislation was the Housing Act from 1925, and this used a value assessment on the basis of the, quote, land as a site cleared of buildings. Both different ways in which you can calculate and use and essentially conceptualize the concept of compensation, and both pieces of legislation that essentially provided regulation of compensation over the same area of industry and of the compulsory purchase of housing. So you would think, okay, well, what happens here is there is a contradiction between the two pieces of legislation. The previous legislation, too, also sought to protect itself from reform by providing that, in Section 7, subsection 1, if there was a legislation which was inconsistent with the Act, it would have no effect. So not only is there two pieces of legislation, both regulating the same area of law, but are contradictory against each other, but the earlier piece of legislation attempted to try and protect itself from reform by suggesting that anything that contradicts the Acquisition of Land Act from 1919 will have no effect. So if we were to apply this piece of legislation, if we were to apply Section 7, subsection 1 of the Acquisition of Land Act, it would mean that the 1925 Housing Act would have no effect, owing to the fact that Section 7, subsection 1 meant that it would render any future legislation void if it was inconsistent with the Acquisition of Land Act. The issues here are very easy to see. The question was, for the court, A, whether or not the 1919 Act can have this prospective binding effect, i.e. whether or not subsection 1 of Section 7 was actually legal. And then secondly, the question of, okay, well, if that is the case, or if that is not the case, which is the piece of legislation which should take effect? Which of the two should take effect? Now, you should know already the answer to both of these questions if you have been listening to my conversation about implied repeal. Ultimately, it was held that the Housing Act of 1925 had impliedly repealed the Acquisition of Land Act from 1919, or specifically the provisions relating to compensation, and this was the case owing to the contradiction between the two pieces of legislation. As such, the more recent piece of legislation took effect, and Section 7, subsection 1 was null and void, owing to the fact that it would be a violation of parliamentary sovereignty. The final thing I want to talk about in relation to implied repeal is this idea of how this operates in relation to the law of the European Union. Because, of course, even though we are no longer members of the European Union, the concept of EU law was very much a substantial element of the UK's constitutional framework going back to the 1970s when we joined. According to Section 2, subsection 4 of the European Communities Act, 1973, it says that the provision that may be that may be made under subsection 2 above includes subject to Schedule 2 of this Act, any such provision as might be made by Act of Parliament, and any enactment passed or to be passed, other than one contained in this part of this Act, shall be construed and have effect subject to the foregoing provisions in this section. Essentially, what this provision is telling us is that while the UK was a member of the European Union, the concept of implied repeal seemed not to apply to the application and implementation of EU law. We will get to the concept of EU law in the future as a challenge to the traditional view of parliamentary sovereignty, but for now keep in mind the idea that there are elements of the UK's constitutional framework which did, and still to this day does, present something of a challenge to the concept of this traditional view of sovereignty.